The honourable member for Calgary Mountain View.
Much, Madam Speaker. Pleased to make comments on second reading of Bill 4, which proposes to amend the Public Services Employee Relations Act and the Labour Relations Code to make them compliant with the recent Supreme Court decision upholding public sector workers' fundamental right to strike. The legislation guarantees public sector workers the right to strike with the caveat that unions and employers must agree on a contingency plan in the event of a labour disruption. As far as the outcome of this bill, unions and employers will be required to have an essential services agreement in place before proceeding to collective bargaining. Such pacts will determine which workers are needed to maintain vital services and therefore must stay on the job during a strike or lockout. In the case of nurses, for example, the agreement would likely detail how many employees are required to keep basic hospital services running. The use of replacement workers will be banned for groups covered by an essential services agreement. In cases where the parties are struggling to reach an agreement, they can bring in umpires to adjudicate the dispute, and these umpires will be required to settle quarrels about existing agreements, and in the case of health workers, for example, would be people familiar with hospital scheduling and issues related to safety. It's important to remember that Alberta is unique apart from Prince Edward Island as the only two jurisdictions that do not have legislation to allow essential public workers to strike. Bill 4 covers about 150,000 unionized workers under 77 collective agreements, including most health workers, government employees, and non-academic staff at post-secondary institutions. Bill 4 is a sea change in Alberta, Madam Speaker, from the former PC administration, which tried to legislate away freedom of association, which is guaranteed by the Charter of Rights and Freedoms, and imposing, as it tried, wage settlements. On the whole, the bill is a fair and balanced response, in our view, to rulings by the Court of Queen's Bench and the Supreme Court, which declared it unconstitutional for governments to impose a blanket ban on strikes. Bill 4 effectively guarantees public sector workers the right to strike while still ensuring access to public services in the event of labour disruption. Perhaps the most striking thing about Bill 4 is that organised labour supports it, which is a far cry from the diametric opposition the PC Bills 45 and 46 created in the last 5 years. And this speaks, I think, volumes about what's possible if we can get labour peace and fairness perceived on both sides. Many of the political right will decry the so-called judicial activism in relation to the Charter of Rights and Freedoms, yet this issue is a perfect example of how the courts can intercede when governments are running roughshod over fundamental rights. The reason people go out on wildcat strikes is precisely because they're desperate. They cannot find any other way to communicate with their employer, in this case the government, to get a point across. They absolutely must have that option. All of us will benefit, and Bill 4 provides that with a reasonable caveat, under Bills 45 and 46 of the previous PC administration, it left workers no option and no bargaining opportunity. The ability to go on strike is really the only card that workers hold as a tool to ensure some element of accountability and fairness. So, Madam Speaker, pending more detailed examination, I appreciate that the leadership taken by the Minister, and I look forward to hearing more of the elements of the debate that need to come out, the details around the Commissioner and his or her role, and how we may ensure that both sides get, both the public and the union members get a balanced approach, which is, I think, what the role of government is, to try and provide a balance of rights and freedoms on both sides to ensure that the public interest long-term is being served. Thank you, Madam Speaker.